Well, good afternoon and welcome to today's webinar. This week is Sexual Abuse and Sexual Awareness Week, and I'm delighted to be joined by Dino Nocivelli, a partner at Leigh, specialising in actions for child sexual abuse survivors. My name is Anirudh Mandagere, and I have a practice in abuse claims, including failures to protect and investigate abuse. Now, today's webinar is on abuse in sport, which sadly occurs in all sports and at all levels. This webinar will be split in two parts. The first part will be an outline of two of the principal cases concerning abuse in sport. And the second part will be a conversation between Dino and I about the issues that crop up in abuse cases involving sport. I should note that today's content may be distressing. It's very likely to be distressing, in fact. And it's a point that I wish to just emphasize before we start. The first case is TVZ and Manchester City Football Club. The facts concerned 8 men who had been sexually abused in the 1980s by a football coach, Mr. Barry Bennell. They brought a claim against a football club, Manchester City, and the essence of the claim was that Manchester City was vicariously liable for the sexual abuse levelled by Mr. Bennell. The two critical issues in this case concerned limitation and vicarious liability. I should note the club did not challenge the fact of abuse. Now, this claim was dismissed on 2 grounds. With respect to limitation, Mr. Justice Johnson accepted that there were cogent reasons for the delay because of the effect that abuse and the abuse had on the claimants. However, the difficulty was that much of the relevant evidence concerning vicarious liability had been lost due to the passage of time. The evidence about the club and Mr. Bennell and their precise relationship had to be based largely on witness recollection. And in light of this, Mr. Justice Johnson accepted that the club could not have a fair trial, and it would not be equitable to disapply limitation under Section 33 of the Limitation Act. In any event, having regard to the vicarious liability, the court found that Mr. Bennett was an unpaid and voluntary scout. His position could not be regarded as akin to employment, and further, the abuse that he levelled at the claimants could not be regarded as being so closely connected with the club such that it was carried out by him in the course of his duties. The second case, which I wish to deal with, is Blackpool Football Club Limited and DSM. The facts of this case concerned another unpaid scout, this time for Blackpool Football Club, and it concerned historical events in the 80s and 90s. The critical point of this case was the fact the scout, Mr. Roper, took a squad of young players on tour to Thailand and New Zealand. He bore the cost of the tour, and the club had no knowledge of it. It was accepted that during the New Zealand leg, the claimant had been abused. Now, at first instance, the claimant succeeded in disapplying limitation and proving vicarious liability. However, on appeal, the club succeeded in finding that they were not vicariously liable. And the appeal succeeded chiefly because the Court of Appeal found that the High Court had erred in their interpretation of the facts. The relationship between the scout and the club fell far short of being akin to employment, given the degree of independence given to the scout. And in any event, the New Zealand trip, the cost of which was borne by the scout, and which the defendant had no control over, could not be characterised as the official business of the club. There was no conferral of authority such as to create vicarious liability, and the claim was dismissed. With those cases in mind, I'll stop my screen share and I'll turn to Dino. Hello, Dino. First of all, it's a pleasure to have you here. Thank you very much.
Thank you.
Yes. I suppose the first question I want to ask is, from your perspective as an abuse claims lawyer, what particular issues arise when dealing with abuse claims in court, in sport?
Yeah, dealing with abuse survivors has a number of inherent difficulties. Every client is different, of course, but there are some specific client care issues there which are important. Litigation is difficult, and we have to often discuss very personal information with clients. There's then the actual legal cases which face a number of hurdles. First one often is limitation. Most abuse survivors come forward a number of decades after the abuse, if they can at all. We need to address vicarious liability, identify a viable defendant, and then look at causation and quantum. And obviously, it's very different to a road traffic accident, for example. So if I walk outside my house today and I get run over, I can clearly identify that car accident broke my leg, it damaged my clothes, and these are my losses. But when we're talking about childhood sexual abuse, often we do need to look back and consider what your life would have been like but for the abuse. And that's the whole purpose, obviously, of a personal injury claim. And the last point is also considering quantum as well, and potential financial losses flowing from those physical and psychiatric injuries.
Yes. I should mention in TVZ, that Mr. Justice Johnson actually examined quantum, had the claimants won. And he identified that while it was difficult in some cases, he was able to identify that the claimants could have recovered for loss of a footballing career in some cases. So it can be done, but it is, as you mentioned, given that we're dealing with quite historic cases, it can be quite difficult. Now, you mentioned earlier that these matters, these are often historic cases which come back, decades on almost, and that was something reflected on in TVZ and DSN. And they said that in some cases, the effect of the abuse inhibited the claimants from disclosing it earlier. From your perspective, what do the courts mean by that?
So when we're looking at limitation, if you suffered injuries and abuse as a child, you've got until your 21st birthday, in essence, so 3 years past the age of majority. Now, most abuse survivors don't come forward for a number of decades afterwards, as noted by ICSA, the Independent Inquiry into Childhood Sexual Abuse, and there's often numerous reasons for that. Sometimes it's the inherent element of shame and embarrassment. It may be because the abuser is someone who's a trusted member of the family or in a clear position of trust, such as a football coach or a priest or a teacher. And often, sadly, it's the actual psychiatric injuries from the abuse. If you have PTSD, mixed anxiety, depressive disorder, anything which could be re-triggering or could be re-traumatizing often prohibits you from obtaining the medical help and support you need, the ability to speak to those closest to you, and of course, the ability to speak to the police and or lawyers to pursue a civil action. All of those can act as barriers to disclosure and then act to difficulties in pursuing things further as well.
Yes. It's worth noting that the High Court actually reflected on this in TVZ, and they talked about what's called a compartmentalization. I don't know if you have any experience in your case in terms of this phenomenon called compartmentalization.
Yeah. Yeah, the ability to compartmentalize or to attempt to do it, they may seem the same thing, but actually they're very different. Lots of abuse survivors will say that, what we try to do was to continue with our lives. What we try to do is to put these awful thoughts and memories and impact into a box and continue with our lives as best as we can. But the sad reality is that these things are often all overcoming, in that this will define your life in numerous manners. We've had clients who've suffered abuse, let's say, within the music environment, and then decided to leave that career completely or never go back to a choir or to leave a religion or to try to cope as best they can and to try to survive. The ability to compartmentalize isn't usually borne out in the facts, to be totally frank. It will come out in the way you interact with adults in positions of trust. It may come out in relation to your relationship with alcohol or drugs, self-harm, suicide attempts, difficulties in relationships. So when we talk about compartmentalization, we are talking about the ability to try to cope on a daily level and a daily life, but often you are hamstrung by the issues you've suffered because of the abuse.
Yes, I imagine in some cases it's almost a coping mechanism, an attempt to carry on and compartmentalize, but
Yes.
ultimately can manifest in other ways. In the sporting context, it's notable that the two cases I mentioned were football related, and I think there's been a lot of publicity and a lot of awareness about it in respect of football. What about in respect of other sports?
Yeah, one consideration to be had is that ICSA, which is the Independent Inquiry into Childhood Sexual Abuse, looked into a number of different areas, published their report in October 2022, but one of the main strands which they did not look into was sport, which is something which we did campaign for a long time. And you're right, 2016-17 abuse in football was exposed by Andy Woodward and others. And sport is such a popular thing for so many children. We have seen, scandals in quotation marks for abuse in football, abuse in gymnastics, swimming, tennis. But each time what we see is that a scandal is needed to enable those survivors to come forward. Every abuse survivor has different reasons for coming forward, but often they need to see justice being done to then be able to act on it. The number of men and women who came forward after Andy Woodward was nearly 900 individuals in totality, and continuing, to be frank, in football. But we are seeing similar after Athlete A for abuse in gymnastics, after abuse in athletics and tennis. Every single sport has different issues, but there are common denominators. It's usually a coach who's in a position of trust, power, and authority over an athlete who is usually a child, and then that abuse then affects their lives and often may not come forward for a number of years, which allows the abuse to continue, sometimes with other athletes, sadly.
You mentioned Andy Woodward. For those who are not familiar with the case, what was that about?
So Andy was a young footballer who had a coach called Barry Bernal at Crewe Alexandra Football Club, and he was sexually abused by Barry Bernal, who was subsequently convicted of abusing him. He came forward in November 2016 through The Guardian and then Victoria Derbyshire, who's a BBC presenter, to disclose his abuse. And subsequent to that, like I said, hundreds of other men and women as well came forward to disclose not only their abuse in football, but in other sports and other areas of society. It resulted in an inquiry by Clive Sheldon, KC, who's now actually a High Court judge, looking into abuse in football. But the one thing which we've been demanding for a long time is an independent sports ombudsman. I think that we shouldn't be relying upon individual sports to be regulating these issues, and we do need to have someone who's independent and arm's distance away, so athletes can trust that this will be investigated fairly and openly and properly. But we're not there yet. So as a result, we are still dependent on individual sports to address these issues, and each sport is dealing with them very differently, to be total respect.
Right. Yes, thank you for that. In terms of people coming forward, I think one of the big events that encouraged people to talk about abuse openly was the Savile scandal, the Jimmy Savile scandal, and since 2012. And in your view, what was it that about that scandal that caused such a watershed?
I think abuse has been hidden for far too long. And when a light is shined on the darkness, it does encourage survivors to come forward. So in relation to Savile, it did allow lots of people to come forward. And whenever we see things such as abuse in boarding schools, for example, Nikki Campbell has talked about the abuse. It has encouraged those specific abuse survivors to come forward. It's still inherently difficult for people to talk about these issues. It still remains a taboo in relation to talking about sex openly, let alone sexual abuse. There are barriers to be had, whether it is a child or as an adult, and there are still lots of rape myths and sexual abuse myths about the typical abuse survivor, about the stereotypical abuser. And often the truth is hard for people to accept. And that, when we were both raised as children, our parents would tell us, don't go to the park and speak to a random stranger. But they didn't say that about a sports coach, about family members, about religious leaders, about teachers, because they're respectable. And why would you raise questions about these individuals? That still remains an issue today, as it did when we were both children, and remains an increased risk because of the internet and safeguarding. So what we need to continue to do is to shine a light on these issues and not just to listen, but to act on it. There's still a disconnect, and that's what's been shown by ICSA recently. 20 recommendations. October 2022, we're now in February 2024. How many of those been implemented? And when will they ever, if ever, implemented as well, which is a significant concern?
Yes. One of the issues which there's at least will try to be implemented, hopefully, was the issue of a mandatory reporting duty. Now, actually, when I first discovered it, I was quite shocked, actually, that there was no mandatory reporting duty in relation to abuse in England. I believe it's a case in Wales. But there is slow progress. I think the government's setting out a consultation on mandatory reporting in that sense. I think the first question is, why has it taken so long?
Yeah, when we talk about progress, I think you're perhaps a little bit kinder than how I would term it. When you spent nearly £200 million, and one of the key recommendations is mandatory reporting, and what it means is that if you're aware of abuse happening to children, or you have significant suspicions, you should be under a legal duty to report on it. And the reason why that's so important is that for far too long, the burden of abuse has been on the shoulders of children. We also need to take responsibility. It takes a village to raise a child, potentially takes a village to abuse a child. And I think there should be criminal repercussions for those who fail in their duty of care. We've been relying upon the morals of priests and teachers and others for far too long. It doesn't work, as we've seen. So as I said in The Guardian earlier this week, I think it was actually, we do need mandatory reporting as soon as possible. We need to stop child abuse and we need to act on it. Why has it taken so long is a very valid question. Why has the government done, spent nearly £200 million on an inquiry, done one consultation, done a second consultation? Sometimes the answer you want is not the ones you may be willing to accept. Will this be put in place prior to an election, which will be in, May, November? Maybe, maybe not. Will it be the new incoming party, which looks like it may be Labour, maybe not? Will it be the head of their priority coming 2025? Who knows? But every single day, we've got children at risk. And when we talk about mandatory reporting, it does need to have teeth. It can't just be, you get a slap on the wrist and that's it. It has to have criminal repercussions, as it does in France and in most states in America and Australia and the developed world. The question is why? And I don't know what the answer is, because the fact is, it's a really important tool, I believe, that could help abuse survivors, take the burden off them. And surely as a society, we want to stop abuse, because sadly, there is no cure to the repercussions of this horrendous acts.
Yes. You mentioned France, Australia, and the American states and their sort of mandatory reporting duty. I'm just thinking ahead to think because I imagine this sort of mandatory reporting duty will happen, but we don't know when. I imagine it will happen.
I hope so. Yeah.
I'm being optimistic.
Yeah.
From the experience of France and other countries, what sort of repercussions would happen in that respect?
It just reinforces the fact is that if you've been informed of abuse, you have high suspicions, you need to report it to the authorities. That in itself creates three changes actually. One, it may stop other children suffering abuse. Two, it may mean that the abuse of that child stops sooner rather than it continuing, and it enables them to obtain the therapy and support and justice they deserve then. So imagine an abuse survivor getting justice when they're 14, 15, rather than when they're 40. The ability to rebuild that child's life and to help is so important. The third, and an important point, it protects the whistleblowers, the heroes, the people, in essence, doing their job. The fact is, it's not about you grassing up Dave, the teacher. It's about you reporting valid concerns about safeguarding of a child and you being protected as well. So on all 3 points, it needs to happen. And the end result is that it stops abuse. It reduces the burden on the economy. We were talking about mental health provision, drug rehab, lots of clients sadly who suffer criminal records because they rebel against the system. enabling those people to be helped when they're children will be better for them long term, for society, and it will hopefully eventually stop abuse as far as we possibly can. It's not a magic cure, but it will reduce the number of people being affected by these crimes.
Yes, yes, very well said. We've spoken largely so far about sort of the physical and sexual abuse, but one form of abuse which isn't really understood at the moment, it's very new, is the idea of emotional abuse. Can you tell our listeners what exactly is emotional abuse?
Yeah, when we talk about emotional abuse, there's different elements, emotional and verbal abuse. I dealt with a number of racial abuse cases against the football club for clients who are children. We're dealing with a number of cases of emotional abuse and body shaming within ballet and dance, actually. Now, there's an old adage, sticks and stones will break your bones, but words won't harm you. And increasingly that is untrue. The fact is, emotional abuse is often by people who are in positions of trust to very young children, which is intended to damage and affect them. It's intended to inflict injury that is then caused by their conduct, and the injuries are often psychological and psychiatric and can be long lasting. When we're looking at abuse in ballet and dance, a number of our clients have got significant eating disorders and body dysmorphia. When we were looking at racial abuse, a number of clients have got psychiatric conditions from PTSD and onwards. And it is important for people to realize this is, again, an adult in position of trust, inflicting abuse and harm to children. And it's an area which is increasingly people are becoming aware of, and what we need to address is to act on those. Any form of abuse to a child has to be given equal weight and be considered properly. And this is one of the main criticisms in relation to abuse in gymnastics. It's extremely prevalent there, as found by Anne White, Casey. The question is often, why was this able to take place? How did people not act on it sooner? And the repercussions, a significant number of children who are now adults suffering with the repercussion of that abuse.
Yes, yes. I think one of the great documentaries on this, Athlete A, I think really shone a spotlight on it, not just the physical and sexual abuse, but also the emotional abuse and the turmoil meted out. You mentioned sort of the intentional infliction of injury, which I think just from a legal viewpoint, the first thing I thought was almost the Wilkinson and Downton line of case law, which it's
Yeah.
it's usually very rare. I've never really pleaded it. You only really see it in textbooks, but I suppose that it's going to start becoming more and more important. Can you explain what exactly is intentional infliction of injury in that respect?
Yeah, you're right. So the tort was based on Wilkinson and Downton and then followed through most recently in the case of Rhodes and elsewhere. We have used it in and will be using it in emotional and verbal abuse cases, and it has three components. So one is the intent to cause harm, and there are nuances around that. The second is conduct, then a clear line of conduct which constitutes the tort, and the third is then harm. It has to result in a psychiatric injury. It is a rarely used tort, perhaps, but when we apply it to these cases, you can quite clearly see that can only be what's happened here, actually. And a number of these cases have settled on that basis. I anticipate a number of them will have to go to trial to be tested to look into these these three separate parts of that tort. But it is extremely important because the fact is, when we see a culture of abuse, whether it be verbal abuse, bullying, neglect, emotional abuse, we then also often see the worsening of that abuse. And it then follows on to, usually or normally, physical abuse and sexual abuse within that context. And that's why when I'm very keen to talk about abuse, we need to eradicate it in all of its forms. This isn't being PC or woke. This is clearly talking about safeguarding. It is unacceptable to do this to children and or adults. And that's why when we talk about abuse, we do talk about the wider context. But you are right, the tort is the Wilkinson and Downton basis.
Yes. So almost taking a step back, as it were, this almost might seem an obvious question, but it might be worth getting black and white. Why do survivors of abuse wish to bring, say, a civil claim against a sports club compared to, say, criminal prosecution or any other such like?
When we talk about the purpose of a civil case, often there's numerous reasons. Now, in relation to a criminal matter, that's against an individual. We talk about corporate responsibility in a criminal sense. It doesn't really exist when we talk about sports clubs. So the claim is against an individual coach. Let's call him Dave for ease. So that's against Dave for what he did to you. However, the only result of that can be obviously cause criminal justice and closure in that respect, but it's the abuser being punished. It doesn't really address the survivor. Often in the criminal justice system, survivors feel like they are passengers rather than drivers. In a civil case, it is different because you are the driver. The point is, what has been the impact on you? The reason why people bring civil action is for numerous reasons, but they include trying to obtain an element of acceptance of responsibility from an institution, which again are not on the stand in a criminal case. They want people to accept the abuse happened and to appreciate the impact on them, and not just through an impact statement, which will affect sentencing of an abuser, but actually this is not only what's happened to me in that kind of moment, but the following years and the potential lifelong impact of abuse on myself in relation to drink, drugs, self-harm, suicide, relationships with my parents, with my partner, with my children. They want an apology. Often, which cannot be obtained from a criminal court against an abuser, and of course not against an institution which are not on the stand. And lastly, they want action to be taken. The whole point of a civil case is sadly money talks, and putting this in place, it would mean that if a defendant does not want to, and most sport institutions are good institutions, of course they are, and they don't want abuse to happen, but it does raise it to the fore that you are being brought to account for the failings which have taken place, or from abuse, and you're being held vicariously liable for those failings of an abuser. But resulting in change. Most survivors, all survivors, don't want this to happen to anyone else. And anything they can do by raising awareness, by raising civil actions, by forcing institutions to improve their safeguarding and to ideally stop abuse is what they do it for. Those are some of the reasons for pursuing civil cases. And it isn't, as we sometimes hear, about money. Money is a byproduct, but it's the only way we can raise attention of these issues. All survivors would prefer not to have been abused. All survivors prefer to stop abuse, and what they want to do is often to engage with these institutions, not just sports clubs, but others, to generally result in change. This is what happened to me. This is how it made me feel. This is how you can do better, and hopefully we can all stop abuse going forward.
Okay. Yes, thank you. Because I also do seeker claims as well, which are criminal injury compensation claims, and which often concern issues of physical and sexual abuse. And those matters are the things what you mentioned there. They're all things that are also prevalent in those matters. The idea of taking control, being able to shine accountability. But speaking of accountability, often survivors of abuse they lack trust in institutions and authority, and then they also have to go to lawyers. And I'm just wondering from almost from a practical perspective, how can lawyers, and especially junior lawyers, help foster that trust?
I think it's sometimes just sitting down and trying to understand what the core issues are and the core aims are as well, actually. Survivors do have an inherent distrust of people in positions of power, trust and authority, such as lawyers. They're talking about something which is very personal to them, such as abuse in their personal lives, and exposing this to a random stranger. And it does take time. It does take understanding. And I think that every single time you think you understand an abuse survivor, someone will come to you with another issue. Every abuse survivor is different. Every case is different. Every abuser is different. Every institution is different. And it's to understand, to appreciate even things like communication. You may just go, you know what, I like sending emails, so I send emails to everyone. Well, it's all detailed. As lawyers, we love emails. We love letters because we can put it all in detail, do little subheadings, do bullet points, go crazy. And that's what we do. But for lots of clients, they don't like that. It's very black and white and very personal. Some don't like telephone calls. Some like text messages. Some prefer calls only during work hours. Some prefer them after work hours because they don't feel able to talk during the day. Some prefer their partners to be involved. Some don't. And I think it's just understanding the client's needs and difficulties and working with them. It's then also being totally open and frank. I think far too many abuse survivors are given an idealistic world of the view of the world, which is, we're going to do this, we're going to do that, and this is the result. We need to explain to them the difficulties in bringing cases, but in a human manner, and to work with them going forward. And it's very important you work with your client rather than for them, or they feel that you're kind of in a parental mode and they are just listening to you, nodding around, going, yes, yes, you're right. It's really important they do understand and they are engaged and they feel, again, they are the driver rather than a byproduct or a passenger. But it does take time, and there will be breakdowns during a case whereby that will happen, where they will just feel that, this is too much, this is too difficult, and you just got to work with them. But it's an issue which every lawyer, I think, has in different aspects, but especially with an abuse survivor, because they are inherently distrusting of you. And even, for example, today, so obviously I'm a solicitor, you're a barrister. They often consider us to be, elderly. I don't think either of us are elderly at the moment. And they often have a depiction of lawyers as being stiff, old, wearing suits and ties. No disrespect to you, but it's an issue, and often they just want you to speak normally and to them on a human level. And I think all of that helps to build rapport and trust. But it's a continual issue for abuse survivors.
Yes, it is. Yeah, it's something that we think about because as barristers, we always come in at the very last stages or on the latter stages. We spend time looking over, but in the background, there's always been so many things we just don't know about that's been happening out in the background.
Yeah.
Because frankly, it doesn't concern us in that respect, and it's something that whichever side you're at for, to have that sort of like that understanding, it is really important. So with that round, I probably should have led with this from the start, but what actually led you into this area of law? What's your background?
So when I first entered law, I come from a very working class background. I only really knew about criminal law when I was growing up, so there's lots of criminal experience. But I realised quite quickly that crime doesn't pay in any sense of the word, and it's a very difficult area to go into. And I decided to become a corporate lawyer instead, because I can speak a number of languages fluently. But I hated it with a passion. No disrespect to any corporate lawyers, it's very different being a contentious and a non-contentious lawyer. And I found corporate law very dry, and it wasn't for my personality. So then I went into litigation, did family law, personal injury, employment law, and then decided to become an abuse lawyer about over 10 years ago, because I felt it was really important. As a lawyer, there's a number of areas which are continually changing and challenging in relation to limitation, vicarious liability, heads of loss, causation, quantum, different defendants. I could see the benefit of doing this and trying to help individuals and trying to change the law. And I've been really fortunate to work with lots of MPs to enact laws and to change them as well. I'm very fortunate to do lots of pieces in the media to expose abuse. And for me, the ability to make a difference, which I know can be cliche, but generally, the fact is we are helping individuals, we are helping abuse survivors. And fair enough, I would have earned a lot more money being a corporate law. But, when I look back at my life, I hope I would have helped individuals. I hope I would have changed things. And my main aim is to make sure the next generation are a lot safer than we are now. And we do that by raising awareness, by bringing civil action, and by changing laws. There's still a lot more work to be done. And I think during my career to date as an abuse lawyer, we meet lots of really amazing people as clients. We meet some amazing lawyers, claimant and defendant, to be frank. And what we want to do is to engage with all parties. And we all should all have the same objective. But this law is challenging in every single manner of the word. And I find that really rewarding, the fact that we're able to help and to change. So yeah, long may it continue, hopefully. But hopefully one day we'll be able to be at the point where either the numbers of people suffering abuse is reduced significantly, and the age of disclosure is reduced as well. It's a really keen objective for me. So instead of people coming forward on average roughly when they're 40 years old, let's get it down to 14, 15 and not younger, because that way we're able to stop others suffering abuse. We're able to stop the duration of the abuse for that individual involved, and we're able to get there and help that individual as young as we possibly can. We're not there yet. We need to do a lot more work, but hopefully one day soon we'll get there.
So one thing, or a number of things actually which interested me about that. I think first thing you mentioned, obviously, the fact that you spoke various languages and you have the international background. And it just struck me of the Blackpool and DS enclave that had always had a cross-border element in terms of New Zealand. Is that something you notice essentially in sort of the cross-border issues that arise out of abuse cases?
Yeah, when we look at this issue, most of the work which we do, obviously, is abuse in England and Wales. That's the jurisdiction of England and Wales. In relation to cross-border or foreign jurisdictions, it is about abuse taking place here, being built up here, the relationship clearly being identified in England and Wales, and the defendant and claimant usually being based here. But sometimes you do get school trips abroad. With sport, there's lots of international involvement because the fact is football clubs play abroad, tennis tournaments are abroad, gymnastics competitions are abroad. So there is quite often that kind of crossover, to be frank. We do need to go back to the basics, though, of, is it not only the jurisdiction of England and Wales, but also is it the right forum and venue as well? And what we do find is often the answer is yes to all of those points, and we are able to pursue these. Obviously, this wasn't an issue in DSN. Actually, there were other issues, as you've identified, but the jurisdiction, the forum, and the governing law were England and Wales throughout, and that was, found and accepted by the court as well.
Yes, absolutely. If anyone wants to learn further about essentially jurisdiction and foreign law issues, or even furthermore about abuse issues in general, I highly recommend abuse briefing that Deka Chambers has put out dealing with these issues, including the thorny issue of abuse cases in package travel issues. There was a recent case, X and Coney, which dealt with this in relation to the preceding ones, but that briefing by Sarah Prager and Carrie Nicholson in relation to cross-border abuse is very informative. We've talked a bit about essentially the liability in terms of sports. Just want to move on briefly just to talk about quantum, though I might go back to liability again. What types of damages, what types of heads or loss are you likely to see in an abuse case?
So when we're looking at abuse and focusing on personal injury, it usually focuses on two elements. So one is general damages, and the second is special damages. So general damages refers to pain, suffering, loss of immunity. Can also include aggravated damages, which is in essence, the abuse is either of a particularly despicable and demeaning nature, and or it was inflicted by someone who's in a position of trust, which obviously worsened the impact of it. When we talk about pain and suffering, we're looking at not just the physical, sometimes there are physical injuries from the abuse, because there's an adult abusing a child, but also the psychological and psychiatric injuries flowing from that as well. The second aspect, we're looking at special damages, and what that means is the ability to put a financial figure to the losses. Now, that could be past therapy, it could be future psychological therapy for the individual. It could be past loss of earnings, future loss of earnings, potentially loss of chance. It can be potentially reconstructive plastic surgery. A number of our clients have self-harmed. They may need plastic surgery and or camouflage. Sometimes they may need colorectal surgery as well, dental costs, in addition, potentially from use of drugs. But that's a distinction. The one aspect, general, is looking at the personal impact on the individual, and the second is special, looking at the financial losses, in essence.
One issue that I mentioned earlier about TVZ is about calculating future loss of earnings in respect of abuse, because what you're dealing with there is really loss of a chance. And I guess for many people watching this, it can be quite difficult to envisage what could have happened or what would have happened. What sort of issues, what sort of evidence would you really look at in that sort of case?
Yeah, so when we look at a loss of earnings claim, we first need to consider, but for the abuse, what would your life have been like? And to date, I've never had a client who's had an identical twin who has not suffered abuse. But that's the whole point of the judge, and that's the point of us, actually, to identify what your life would have been like. Now, when we look at loss of earnings, if you're going to say you would have been a tennis player, a track athlete, a footballer, it isn't a standard career. So when I gave that example before of a road traffic accident, if I had a car accident today, what would my life have looked like? For a loss of earnings perspective, I can show you over the last 5, 10 years, I've been a partner, I've been a lawyer, I've been a solicitor. In the next 5, 10 years, these are my rough earnings, is what we could project. And we could look at similar fact evidence, the other partners in my law firm, for example. When would I retire? On average, it's X date, and you can figure it out. It's easier with certain careers, teachers, doctors, lawyers, and the like. With sport, it's such an unknown, to be totally frank, because there's a number of different factors. One, would you have made it? Two, if so, at what level? For football, Premier League, Championship, League One, League Two, non-league. Thirdly, how long would you have been in that level, and how long would you have been in each division for? Fourthly, injuries. Your career could be totally curtailed. And fifth is the unknowns. What I mean by that is that if you're a goalkeeper, you're less likely to be on a football game or to be a Proclaim advert than you are if you're David Beckham as a midfielder or a striker. You don't get goal bonuses for certain positions, or you may have a higher sum. You may move between clubs and get signing on bonuses, or things like this. And we also then need to consider not just your footballing career. When does an average footballer retire, for example? But what happens to you then? What do? You retire, let's say, 35. You've got a long life ahead of you, hopefully. So what do? Do you become a manager? Again, in relation to management, do you remain in a position like Alex Ferguson for 20 odd years? Or are you like Roy Keane, you're moving jobs every 12 months, and then you just go into commentary instead? No disrespect to either manager, but they are quite different actually. And again, where do you manage? Premier League, different divisions. If you become a commentator, how long for? What channels? What's your salary look like? Do you become an agent? Do you become a physiotherapist? Do you retrain and become a teacher, become a lawyer, as some people have done actually? There's lots of questions to be had, and what we look at is something called loss of chance, like you mentioned. So first thing is to identify, what does the average footballer at this specific club? Again, if you're a trainee footballer at Man United, you're going to have better prospects than being a trainee footballer at Forest Green Rovers, with total respect, and your prospects are higher. But what would an average footballer look like? Looking at the statistics, what would an average footballer earn? Looking at the statistics, and then you need to apply the chance. So if you can get 20 witnesses to say that you would have been the next Beckham or Del Piero or Ronaldo, that's really helpful. But then what is the chance, and what's the chance of you suffering a career-ending injury? The unknown then is management and coaching, and that is a problem. But it's different for each sport. Football, there's so many people playing, the percentages are much less. But if you do tennis, rowing, gymnastics, your chances may be higher, but your earnings will be lower because it's not as popular a sport, the financing isn't there. Each case needs to be done individually, but you are right. For two of the cases in TVZ, there were findings that they did lose a chance to become professional footballers, which included at the highest levels of the game. And there have been other instances whereby people have suffered career-ending injuries in sport. And again, those findings have been made, whether it's martial arts, whether it's football, tennis. But it is reliant upon the evidence. And often it has to be tested at trial, to be frank, because the difference between making it and not is so significant. If you can't resolve the matter through negotiations, then it has to be adjudicated, sadly.
Yes, yes. One thing, yeah, another thing, a point which I was just thinking about just there is the issue of rehabilitation and therapy. And I think from my perspective, it sometimes almost ends up with barristers, it just becomes numbers on a spreadsheet and how does it work on. So you don't really get to see sometimes the practical impact of it. Just in your experience, what's been the practical, how can sort of the rehabilitation therapy help survivors of abuse?
Yeah, it can be really significant, to be frank. But it's really important to consider when we talk about therapy that there's 3 stages. Okay, so one is during the life of a case. Can you obtain therapy? Is it beneficial when you're still going through the trauma of the abuse, because you're going through a litigation, you're talking about it? Secondly, is once the case is settled and you've got that resolution, hopefully, justice, closure, the ability to move on. And then third is potential relapses, because your partner may leave you, you may have a car accident, your parents may die. You may lose your job, may be redundant, there may be other issues in your life. So therapy is important. It does give people often the coping mechanisms, the ability to process the trauma they've been through, And lots of my clients remain in contact with me, and you do see a difference. The resolution of a civil case can mean so much to individuals. The resolution of a criminal case and the ability to process and to explain to their partners, their children, and be able to manage those emotions and feelings and the impact, it's an amazing thing. And often we have to look towards private therapy because even though I'm a staunch supporter of the NHS, the provisions aren't really there for abuse survivors, with total respect. When we look at the number of sessions available, the waiting lists, and the specialism, you need to have abuse specialists providing this to people. And you need to be able to bond with your therapist as well. We've talked about before about rapport. If you are an individual who wants to have a male who's in his 30s or 40s to engage with, having a female who's 60 talking about sexual abuse with you may not work. And we've seen the repercussions of that. A number of our clients have not engaged further. A number of therapists have actually cried during sessions with our client, which is not helpful, obviously, for an abuse survivor. But we do need to have that. And that's why often we're looking at, like you said, the figures, because we do need private therapy, sadly. The NHS just isn't currently, I don't know if ever will be, capable of providing that kind of specialist support to survivors without extensive waiting lists, which could be 9 months plus, to be frank. So so private therapy is very beneficial for our clients.
Okay. Yes, it's something with the parity between physical health and mental health is an aim,
Yeah.
but I think it still hasn't been achieved yet. One question we had beforehand, was about the different sort of courts and tribunals that deal with sort of civil actions. My understanding is I've got obviously the civil courts, the county courts, and you have tribunals in respect to the first tier tribunal, upper tribunal, when you're dealing with seeker claims. The only other one I could think of was sports resolution have a safeguarding arbitration. Is there any that I missed out? But those are the big three that I could think of. Are there any
No,
other sorts of
yeah, you're right. You do have sports resolutions. You can also have, obviously, internal disciplinary proceedings for gymnast coaches, football coaches, and the like. Um, Often, the internal sports, regulatory matters don't have a lot of success because survivors don't trust them. So I suffered abuse by my athletics coach. I now need to trust athletics to investigate themselves, and the athletics coach, Kelsey engagement is very low, sadly. It's another reason why we do need an independent sports ombudsman. Sports resolutions do lots of good work, to be fair to them, but it isn't enough. We do need to have a body to do this. So that means if a child is partaking in athletics or gymnastics or tennis, they have the same ability to report to an independent body to investigate it properly. But you are right. Those are the main tribunals and courts which we look at. Yeah.
Oh, yes. One thing I should have mentioned at the start, if anyone wants to add any more questions, you can put it in the Q&A function or the chat function if need be. They're currently empty at the moment, but if anyone has any further questions or any comments based on what we've been discussing so far, then that would be much appreciated. We've got 10 more minutes, so there's final few points I want to talk about. We've been talking a lot about the impact of abuse on the survivors, etc. But as lawyers, we have to deal with listening with quite difficult issues. And in terms of the impact on lawyers, how can they protect their mental health? How can we, I guess, protect our mental health when dealing with what are difficult cases?
Yeah, I think it's a valid point, and I think it's something which does surprise lawyers. When Clive Showden case, he was investigating abuse in football for the Football Association, he did talk about this and the fact of secondary trauma, and himself and others did have to have counselling. And he's a very respected lawyer, to be fair to him, obviously now a High Court judge. But it does sometimes take you by surprise. I'm a lawyer who's been working with abuse survivors for so long, and you will sometimes hear something or meet someone, and it will shock you, as in it will bring things to the fore from your own personal life. If you have children, it does bring it much more to the fore, makes it fresher for you. It is a concern, to be frank, and especially from our own personal background. I am a child of immigrants. My family are Catholic. I'm a male. Most abuse are men. Lots of abuse happens in the Catholic Church. It can raise lots of questions for you on a personal level about things and how things can happen and how there's so much evil in the world, to be frank. And I think it's important not to compartmentalize it, but to try to address it, whether that's speaking to colleagues. We do lots of secondary trauma training in the firm, because I think it is important. And to be aware of these issues. The fact is, we don't want to become emotionally dead or stunted to these problems, which sometimes lawyers say that, take a stiff upper lip, just crack on. That's the worst thing you can do. You have to care, and you have to have empathy, but you also have to realize where the boundaries are between you as a lawyer and your client. We want to do absolute best by them, but it's your client's case, not your case. You're not advocating personally. But it is a continual issue, and I think it's a really important aspect of this, especially when you have other issues, other stresses in your life or in work. I think it's just about balancing those. The fact that we can see change and hopefully, more change coming is really positive, and we try to take the positives of everything we do in our lives. But so it's a live concern, to be frank.
Great. Well, thank you for that. There's a question that's just been put forward just now in terms of from one of our listeners. How often is loss of chance argued in the courts? Is it considered a difficult element to successfully argue given the variables? What's your thoughts on that?
It depends on the level, for example. So if you consider a pyramid, okay, for any sport, the pyramid is very, very small at the top. So there's only two sections, those who make it and those who don't, with total respect. The ones who make it are very limited because it's such a difficult area to get into. There's only so many positions on a hockey team, on a football team. And most people will be amateur. And that's the level they're at, and that's absolutely fine. You need to consider where the abuse took place. Lots of abuse takes place within the amateur ranks. So you couldn't say to me, a Sunday league team in Norwich, but for the abuse, Dave would have gone on to become a Premier League footballer, because statistically it's very, very, very limited that's going to happen, with total respect. So we're looking at abuse predominantly happening within the professional ranks, and then you still need to assess it, because even then, not every single trainee at Man United or Forest Green Rovers or any other football club would go on to make it as a professional, and at what level. So to answer the question directly, how often is it argued? Predominantly when it's within the professional ranks, but you still need to assess it, and it's not argued in every single case because it's just not sustainable. But to be frank, based on the evidence, where it is argued, it's then it is considered to be a difficult element based on the variables. But we're looking at loss of chance, and the point is, did they have a chance? Yes or no? And the second question is, what percentage? It's not 100%. It's not 50%, perhaps it's 10%, but you do need to then assess it. Could they have entered that field, and then what's the chances going forward? And this applies to every single profession, not just within sport. Could Dave have made it as a lawyer? Could Dave have made it as a doctor, as a teacher, whatever else? If so, where would their career have panned out? Would they have been a partner by age of 30, 40, 45? Would it have been a high street firm, a magic circle firm? These are variables which we assess as lawyers every single day in every single profession. In sport, there's less statistics often because it is so subjective, so variable. Having the right coach, manager choosing you, making sure you fit their style of play. Again, a footballer at Barcelona will play very different to one at Newcastle. The style of play is very different. The league's very different. So there are variables, but we deal with these, unfortunately, on a daily basis as lawyers. And this often comes down to witness evidence and factual evidence as well, and data.
I hope that answered the question. We've got 7 minutes left. Just final few questions. First, in terms, you mentioned that the historic abuse, but you're seeing more revelations come up now about, for example, abuse in ballet. What differences, if any, do you see between sort of claims of historic abuse and the more contemporary abuse claims that come now?
Yeah, I think it's the greatest fallacy in life, actually, whereby the police refer to non-recent abuse and then recent abuse, or term you use, contemporary abuse and then historical abuse. I think it's a red herring. I think it's a fallacy, and I think it's a dangerous differential to make. We don't have historical murder. We don't have non-recent theft. The reason why I say that is that it's just about the crime taking place is often very similar. We've got clients who've suffered abuse within sport, within the Scouts, in the last 2 to 3 years. But we've also got them which happened 20, 30 years. What's the difference? Nothing. It's still the same position of power, still a child facing hurdles and barriers to disclose. They are continually changing and different for each individual, but it's still the same in the elements of embarrassment and shame and fear of being believed, because it's a public figure, good social standing. and the repercussions can be very significant for that abuse survivor. The impact can be psychological, can still affect drink, drugs, self-harm, their careers. The only difference is that we are able to see a little bit better the impact on someone's life when they are 40 than when they're 14. When you're 14, you're crystal balling. What will the future look like? And as lawyers, we have to assess that. When you're 40, we can not only we crystal ball from 40 until you die, but it's not a crystal ball, is it? The fact is we can see what your life has been like. The question is slightly different crystal ball. What could your life have been like? But we can see the repercussions of the abuse on your life. So that's the reason why I always argue against the distinction between non-recent abuse and current abuse, or historical abuse and contemporary abuse. Abuse is abuse, and I think often we see this in the media as a kind of protection blanket, to be frank. It happened back in the day, happened in the past, can be happening today. It's a lie. Sadly, abuse is still happening at probably the same level. It still takes people 20 to 30 years to disclose now as it did back then. And I think it would be naive of us to say that children, even with all of this public awareness, that it's easier. It's easy for people to disclose. It may be easier in certain circumstances, but it's not. It's still inherently difficult for people to disclose. And that's why, I see abuse is the same. Historical or contemporary abuse is abuse, sadly.
We've got 4 more minutes. I appreciate I've just been throwing questions at you for past 45 minutes. But I just thought to round off, is there anything you want to ask me from a barrister's side in that respect?
Yeah, I think that, as with any students obviously listening, I think it's really important to follow this. This is not, you haven't paid me to say this, but actually the newsletter which you do and Chambers does, it is actually really good. There's a couple of them. Gordon Excel does a really good one. Clyde & Co, which is a defendant firm, actually do a really good blogs about these issues as well. I think from a barrister's perspective, the key question is, I suppose, is when you're assessing cases and prospects, and often we act in these cases on no win, no fee, is to balance the difference between your personal and your professional views on a case. Because on a personal level, I assume you want to help everyone, but you can't. And how you address that. How do you, as a barrister, give bad news to a survivor of abuse?
I think in terms of giving bad news, I would always in issues such as abuse, I would always have a conference rather than just sending an email. Obviously, depending on how they view, because I think it can come across as quite cold if you say that don't have zero prospects for success. I think, and I think about this in relation to seeker claims, it's important to give a sort of percentage level, because I think with the percentage level, people are able to understand it. And I don't think I've ever come across a case where I've said that there's 0% of success. I think every case, I think I would be wrong. I don't think I've ever come across a case like that. But it's about making sure they understand essentially the relative strengths and weaknesses of the case. And in some cases, disassociating it yourself, because it's not really about what I think. It's really about what a court or a tribunal thinks. And I think by framing it in that mind, it becomes less personal. It's not about you making a personal judgment. It's about thinking, what will this third party think? That's what I really think about in that respect. And often, I think when thinking about, I think one of the difficulties I think with abuse cases is you want to obviously like empathize and appreciate the information, but you also need to a certain extent test the information and test the sort of assumptions. And one thing that I often try to do is just try and think about in terms of a court, that if a court asks you this, what would you say? If someone else asks you this, rather than, because of the danger that you might come across as a personal attack if you start saying, oh, these are the issues, these are etc. Well, that's what I do. I don't know what your thoughts are on that.
No, I think that's really fair, and I think it also helps them. Obviously, it's an adversarial process, isn't it? Litigation in this case, and I think it's really important to be logical and reasoned, especially with defendants. And sometimes you do face confrontation with defendants. Most of the time, we don't actually, and they're able to express their points. You can disagree, you can debate points, but again, it's making sure it's not personal and making sure you can both see the end result, which is often assessing what a judge would do, because that's beneficial to both clients. Otherwise, you're expending a lot of time, money, and emotion into a matter which will only harm both parties, to be frank, whether financially or emotionally. And, as lawyers, we shouldn't be doing that.
Okay, that wraps us up neatly at 1 o'clock. Thank you very much, Dino. That was a really, really insightful conversation. I'm glad that we're having this. This will be posted on our YouTube channel as well. So if there is anything that any parts have missed, anyone's missed anything or wants to get the slides, you can get it from there. All right.
Thank you so much for having me. Thank you.
We also take care.
Bye.
Bye.